The Boots trade case, as this case is commonly known, was one of the earlier decisions of the High Court of Australia. We remember this case because of comments made by the judges about Section 109 of the Constitution, which says that if a law of a state is inconsistent with a law of the Commonwealth, then the Commonwealth law shall prevail, and the state law shall, to the extent of the inconsistency, be invalid. In this case, the Boots Trade Employees Federation were arguing for better employment conditions for their employees across a number of issues. Their membership was broad, so the dispute extended beyond any one state. In fact, New South Wales, Victoria, Queensland and South Australia were all involved. Because the dispute went beyond any single state, the Boots Trade employees sought an arbitration by the Commonwealth to cover all 4 states. The Commonwealth arbitrator set a minimum wage of 1 shilling 1 penny and halfpenny per hour, which was more than the minimum wage in each state, which was 1 shilling per hour. The employers, of which Whybrow was one, took the matter to the High Court. Now, most of the High Court decision deals with issues under the Reserved Powers Doctrine and the Doctrine of Implied Immunities, both of which have long since been done away with, so most of the decision can safely be ignored. From our perspective, the real question is whether the state laws and the Commonwealth law were inconsistent, which would give rise to a Section 109 issue. The court found that they were not inconsistent because it was possible for a person to obey both of them. If, say, the Queensland minimum wage was 1 shilling and the Commonwealth minimum was 1 shilling 1 penny and halfpenny, then an employer could comply with both rules by paying the higher amount. They'd be paying the Commonwealth minimum and exceeding the Queensland minimum, which of course is allowed. Justice Barton put it this way: "It is impossible to say that the employer cannot obey one without disobeying the other. Therefore, the former and the latter may stand together. Therefore, according to the proper test, they are not inconsistent." This test is still one of the 2 tests of inconsistency for Section 109. The other one, covering the field, will be discussed in another case called Clyde Engineering and Cowburn.